This is You and the Law on AM 650. Now back to the show.
Welcome back. I'm Sterling Fox, joined in studio by David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver, the law firm that we're talking with today that specializes in the work of wills and estates. And gentlemen, today we're talking about wills variation, which is an outside request to have a will changed. Is that civilian definition too simplistic, Ian, or is that pretty much the nuts and bolts of what a will variation is?
I think that's what we can work with, that sort of description.
Okay.
Sterling.
So someone comes to your offices and wants to talk to you. They sit down. You'll oblige them with a free consultation to get a feeling for at least for what their issue is, and they in turn have an opportunity to talk to you and figure out whether you'd be the kind of guys they'd want to have to go to bat for them. But in a lot of cases, and we touched on this moments ago, in a lot of cases, people come to your office and they are just one human pretzel of emotions. They're just so wound up and so stressed and so just emotionally tight. This is something you encounter in your practice almost every day, but it really doesn't help anyone to go into a situation where they're going to sue somebody because they're mad as hell and they're just not going to get away with that stuff. That's not perhaps the right attitude to take to the lawyer's office, is it? But they do show up kind of wound up like that, don't they, David?
I would say in most cases, I mean, there are some people who handle their emotions, shall we say, better than others, but I think the first thing is you have to respect people and their emotions. I mean, it's not realistic to say to people, don't be emotional or stop being emotional. I mean, we're human beings, are emotional people, and we're all emotional in different ways. So the first thing, I think, is to understand and respect the fact that there are emotions and they are powerful and they exist and they're part of the process. So that's step number one. The nuts and bolts of estate disputes are firstly the estate, and secondly, who are the stakeholders or who are the players. And once you lay those pieces out, that's what you're working with. You've got a pie, it's a certain size, you've got so many people, they might have a share of that pie, and that's the nuts and bolts. The emotions, drive decisions and drive behavior, and really you want to try to recognize them, work with the facts, and look at what a judge might do, other cases, what has occurred in precedents, and find guidance wherever you can to decide what a proper resolution is.
All right, now, Ian, when we're talking about getting past the emotions, in the case of people who come to the office, to Hobbs Giroday, looking for some help, some advice, and perhaps even some, we'd like you to take the case, assuming there is one, once that emotional discussion is held and you have a sense of the facts of the case, do the emotions become a little more appreciable when sometimes they go, you won't even believe this until I tell you. They lay out what the facts from their perspective, and you go, oh my gosh, you really do have a problem. Have you encountered that where you simply are quite struck by the unfairness of the situations that people bring to you?
It's I guess reality's more surprising than fiction, Sterling. We've had people come in the door who've been spouses for over 30 years who have been completely disinherited under their spouse's will, for example. So yeah, there's no shortage of very surprising will drafting.
David, is there vindictive language in people's wills? Ian just mentioned the word disinherited. So, at the end of your lifetime, you're having the opportunity to review and possibly revise that will. And you decided, well, now this person wasn't necessarily, that will I made up 20 years ago that favored this person, that person's performance over the last 20 years has been less than stellar. They're out. So those sorts of revisions get made. That ends up being the final will, and somebody's going to get a spanking or punished in some way by the will maker. What do the courts say about that?
Well, we haven't got into this much today, but it's important that when a will's drafted, it's drafted by someone who knows how to use the language properly. Wills can be subject to interpretation. They can be subject to disputes as to construction, i.e. what does that will mean. So if you're going to go to the trouble to make a will, have it written by somebody who knows how to draft a will.
Right.
Don't write it with your neighbor sitting at the coffee table at home, or because the problem is that invariably the words that you'll use will end up inviting lawyers to have a fight about what was meant. as to any kind of emotive statement about your spouse or your children or anyone else that you may not like, there's really no place for it in the will, because the will is just a series of instructions. It's to how to distribute your estate.
Right.
And an offhanded comment about someone, any wills drafts person would discourage you from doing that. They would put those types of comments in notes that are part of the instructions to draft the will,
Right.
but they wouldn't write it into the will, because this kind of discussion in a will makes a will unwieldy, and it becomes a storybook rather than a will.
So no editorials, Ian. Stick to the facts, the distribution of your assets, etc.
Well, yes, qualified. There's a very important section of the Wills Variation Act which enables a will maker to explain in writing, in a signed document, why they have disinherited someone or treated someone who could bring a wills variation claim less favorably than perhaps their siblings. That can be placed in the will, but more often it will be perhaps an appendix to the will or a separate writing altogether. The important thing, however, is that that writing, the stated reasons have to be valid and rational.
Okay.
They have to be true, valid and rational, and if they're not, they can actually work against the will maker in terms of variation. But there is a place for explaining why spouses and children have been treated in a certain fashion under the will.
Oh, interesting. Okay. Now, we began this conversation a while ago. I was referring to some promotional material I had received recently from the cancer people, the month of May being Legacy Month nationally, when Canadians are encouraged to consider charitable donations as part of their estates. And David, we're pretty good at this. Canadians are a pretty generous people, and many of us leave some portion of our estate to the church or to the Cancer Society or some charitable recipient, don't we?
Yeah, that's correct. We see a lot of people who have relationships with churches and have been church members for many years, making gifts in their wills to their church. They may have made donations during their lifetime as well. This gets a little bit into the size of people's estates, because when you talk about wills variation, one of the important factors is how large is the estate. The concept is that a large estate can provide a very healthy gift to a large group of people.
Right.
And so there's enough to go around, enough to share. That's the concept. And smaller estates are more sensitive to gifts to spouses or children. So, but having said that, if the will maker left their entire estate to the Cancer Society or to a church and nothing to their spouse or nothing to their children, that'd be ripe for a wills variation.
That was my next question. If and no slight at all against the intent of the will maker to give some of his or her estate to a charitable recipient, but Ian, if they got a little carried away and gave most of the estate to a charitable recipient, excluding their spouse and children, the immediate family, then the immediate family members should be hopping down to Hobbs Giroday going, now wait a second, no offense intended here, but we deserve at least as much as the church got.
Yeah, that's absolutely correct. The British Columbia law recognizes that a will maker has an obligation at law to their spouse and to their children.
Infant children.
Well, obligation to both.
Mm-hmm.
A legal obligation to spouse and infant children, a moral obligation to spouse, infant children, and adult children. So, and they don't have that obligation to leave anything to a charity. So it's
right.
An absolute...
And so the law is clear in terms of priorities.
Right.
Family first, and everybody else take a number and get in line. Basically?
Yeah, there's an important case many years ago called Tatter in Supreme Court of Canada. It really explained a lot of the wills variation law. And in that case, there was a long-standing marriage, and the husband did not leave the matrimonial home to his spouse. And they relate a little bit to family law. I mean, if people are married and married for a long time, you'd expect them to have an equal interest in the matrimonial home. Here he'd created a will where his wife didn't receive the matrimonial home, and the Supreme Court of Canada looked at all this and awarded the matrimonial home to his spouse,
Mm-hmm.
and varied the will in that regard. And there's also life tenancies where you allow your spouse to live in the matrimonial home for her lifetime, and the intestacy situation provides for that as well.
So even if mom's got the original family house and the kids would like to sell it and divide the loot up among themselves, as long as mom chooses to live in that house, they can't force her out of that home. True?
True.
Okay.
In an intestacy.
An intestacy, which is the absence of a will.
The absence of a will.
Oh, okay.
Right.
Interesting stuff. Boy, there's an awful lot to know about wills and estates, and I guess lesson one would be try not to be one of the 46% of British Columbians who don't have a will in the summer of 2013, and if you do choose to go the direction of a will, for goodness sake, don't go to the drugstore and buy a kit. No knock against the drugstore, but guys, if you're going to do a will, this is an important document. You better sit down with a professional who will charge you a few bucks, but who will do right by you, correct?
Well, would you do a legal conveyance of your home without the assistance of a notary or a lawyer? I mean, doing a will, your entire life's worth, your physical land, bank accounts, all of your assets are being dealt with through this will. It just makes perfect sense to spend a bit of money to make sure you do it properly.
And I guess, David, too, think about the family and the fight that you could help to avoid simply by organizing your affairs during your lifetime.
Well, I would say, Sterling, you want to take control. I mean, the will is your ability to have control over the final set of instructions, the final distribution. That's your right, and why would you want somebody else to decide those issues for you?
Excellent website these gentlemen and their firm operate, friends. It's hobbsgiroday.com, HOBBSGIRODAY, hobbsgiroday.com. David Hobbs, Ian Giroday, good to see you again. Thanks for coming by.
Thanks for having us.
The Redhead and the Diner are next on AM 650.